Secretary reads Senate Bill 4.
Senate Bill 4 by Senator Dolezal, the 27th, and others. Bill to be entitled an act to amend Chapter 2, Title 20, the official code of Georgia annotated relating to elementary and secondary education so as to revise provisions relating to the fundamental roles of local boards of education and local school superintendents, to provide for requirements for the model code of ethics for local boards of education to be promulgated by the State Board of Education, to provide for public complaints alleging ethics code violations by members of local boards of education, to provide for required and prohibited topics and training programs for local board and education members, to provide for a sanction for non-compliance, to provide for an effective date, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Payne, Vice Chairman. Mr. President, the Senate Committee on Education and Youth offers the following substitutes to Senate Bill 4, bill to be entitled an act to amend Chapter 2, Title 20, the official code of Georgia annotated relating to elementary and secondary education, so as to revise provisions relating to the fundamental roles of local boards of education and local school superintendents, and for other purposes. Mr. President, Senator Dolezal, the 27th, offers the following amendment number 1 to amend the Senate Committee on Education and Youth substitute to Senate Bill 4 by replacing lines 135 through 139 with the following. The General Assembly on the specific topic, or V, that are for or against current, pending, or past, or future legislation affecting public schools or local school systems. Mr. President, that completes the order.
Recognize Senator from 27th.
Thank you, Mr. President, colleagues. Senate Bill 4 does 5 things, and all of them relate to local boards of education. The first thing that Senate Bill 4 does is, if you look on lines 20 through 24, we clarify the role of local boards of education. Currently, there's a line that was put in there about 15 years ago that stated that the job of the local board of education was not to micromanage the superintendent. Micromanage is completely undefined, and that has created some confusion between local boards of education and the superintendents. And so we clarify here that the role of the board of education is to hold the local superintendent accountable for the performance of his or her duties. The second thing that the bill does starting on lines 43 through 51, is it requires the state model ethics code to create a pathway for citizens to file ethics complaints against sitting board of education members. Currently, the state model code of ethics only allows one board of ed member to file an ethics complaint against another. And what we do here is we create a path for taxpayers above the age of 18 in a jurisdiction of that board of education to file an ethics complaint. The third thing that the bill does relates to Board of Education training, which is actually what the third, fourth, and fifth thing relates to. Currently, Board of Education members have annual training after their initial training. So when you get elected, you have 15 hours of training, 9 hours of training every year after that. Lines 91 through 96 clarify that the continuing education is going to cease. So the 9 hours of annual training goes away, and we only keep the 15 hours of the year after an election in place. This aligns with the training that we have for county commissioners and mayors in the current code. And then the fourth thing that we do, beginning on lines 97, is we clarify what shall be a part of this training. And that includes things like code of ethics, facility planning, accreditation, flexibility models, local community relations, parliamentary procedures, roles of the boards of education. And then lastly, the fifth thing that the bill does, starting on line 125, is it states things that the training cannot do, shall not do. And that is to state that local boards of education are encouraged or expected or required to act unanimously. The local boards of education are not authorized to request information from local school administrators. And you can see the list of things there. We had a good discussion in committee. Senator from the 12th and the majority whip, as I understand it, are working with the local board of education on some issues that this bill will directly address. We had some conversation, good dialogue with the senator from the 38th and the minority caucus chair, and that is what brings Amendment 1 before you that I have presented, have on your desks here. So specifically, if you look at lines 135 through 139, the senator from the 38th expressed concern, and I would agree with him, that is currently written. The lobbying language therein really narrowed the ability of a trainer to even say that you should have a pre-legislative breakfast, for example, or that you should have a dialogue between a Board of Education and your local delegation. That certainly was not the intent. So we added it to specific topic, because what has been happening in some of these trainings is you have the staff of, say, GSBA that will come in and provide some training, but then you have a superintendent that comes in. And oftentimes the superintendent will, say oftentimes, it has happened, I can't say how often, we know that it has happened, that the superintendents will come in and pontificate their personal agenda or their personal opinion on things that this assembly has done, and we don't want them to be, we don't want that to get conflated, the opinion of a specific superintendent with the statewide mandated training that we have. So that's what line 3 in the amendment does, and then line 4 and 5 completely rewrite lines 136 to 139 and clarify that these trainings should not include expressions that are for or against current, pending, past, or future legislation affecting public schools or local school systems, which was a cleanup that came from good feedback from the senator from the 44th, and happy to include that there. So with that, Mr. President, that is what Senate Bill 4 does, and I'm happy to answer any questions.
You have no questions?
Thank you. I've wielded well.
Does any other senator wish to speak for or against the bill? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question. Question is on amendment number 1, authored by the senator from the 27th. Is there objection? Without objection, amendment number 1 is adopted. Questions on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the reporting committee, which is favorable to the passage of the bill? Chair hears none. The reporting committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The questions on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 36, the nays are 11. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary, read Senate Bill 124.
Senate Bill 124 by Senator Still, the 48th, and others, a bill to be entitled an act to amend Title 20, the official code of Georgia annotated related to education, so as to require the state school superintendent and the Department of Education to take all steps reasonably necessary to implement guidance documents from a federal agency, including but not limited to directives related to expanding educational freedom and opportunities for families, to authorize the State Board of Education to adopt rules to provide for definitions, to make promised scholarship accounts available to all students whose parent is an active duty military service member stationed in Georgia, regardless of the school attendance zone in which such student resides, to provide for continued eligibility, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Hickman of the 4th District, Chairman. Mr. President, Senate Committee on Education and Youth, I'll refer to the following substitutes. Senate Bill 124, bill to be entitled an act to amend Title 20 of the official code of Georgia annotated related to education, so as to require the state school superintendent and the Department of Education to take all steps reasonably necessary to implement guidance documents from a federal agency, including but not limited to directives related to expanding educational freedom and opportunities for families and for other purposes. Mr. President, Senator Hillary of the 19th and Still the 48th offers the following amendment. Number 1, to amend the Senate Committee on Education and Youth substitutes to Senate Bill 124 by inserting to require the publication and reporting of certain information relating to federal guidance documents following families on line 5 by replacing lines 37 through 38 with the following: C1 with 15 calendar days of receiving a guidance document and for other purposes. And Mr. President, Senator Hillary of the 19th offers the following amendment 1A to amend Amendment 1 to the Senate Committee substitute of Senate Bill 124 by striking lines 31 through 35 and inserting in its place E, the state school superintendent shall report to the above to the General Assembly annually. That completes the order, Mr. President.
Recognize Senator from the 48th.
Thank you, Mr. President. Good afternoon, colleagues. Let's get back to work on something less contentious that we can all agree on: school choice. Some of the most frequently repeated phrases that have been uttered in this well and in committees in the last week have been our most vulnerable, our most treasured, and parents need a choice. Those three phrases truly embody the 33,000 school-age children of the approximately 65,000 active duty military in our state today. Most of these children live on or near a base that's in your district. For example, Kings Bay Naval Station in Brunswick, Fort Stewart in Savannah, Fort Moore in Columbus, Dobbins Air Force Base in Marietta, Moody in Valdosta, Robins Air Force Base in Warner Robins, Fort Eisenhower in Augusta. Those are our primary military bases. That's where the majority of our 65,000 active duty troops live: sailors, soldiers, airmen. And according to the Department of Defense, and those of you that have ties to the military know that the children of active duty military will move 6 to 9 times between kindergarten and graduating high school. Let that sink in. That's moving every 2 to 4 years, usually mid-year, and they're constantly having to adjust. These kids truly are our most vulnerable. They are treasured, and their parents absolutely need a choice about their educational needs. Senate Bill 124 addresses this by directing the State Board of Education to adopt the rules necessary for the state dollars to follow the federal portion as directed by the White House to the DoD. This means that a qualified student who is not already in one of the bottom 25% failing schools will be eligible for a promised scholarship account. We're not adding more dollars to the account. We are simply adding these kids to the list. Talking to a couple of you prior to presenting today, there were questions of DoD schools. There was a question about failing schools in some of these districts. So I'm going to go back to our list of bases, and I'm just going to give you a couple of numbers to let this sink in. In Brunswick, we're doing great. We don't have any schools in the below 25 district. Well done, sir, Senator from the 3rd. In Fort Stewart, in the surrounding counties, we have 3. But no DoD schools, right? So we don't have DoD schools in Brunswick. We do have 3 in the Savannah area, but the majority of the kids go outside. But we have 7 schools failing. But at Fort Moore and Columbus, we have 25 failing schools. We have 4 elementary, 1 middle, no high school for DOD. Dobbins, we have no DOD, but also no failing schools. Valdosta, no failing schools, no DOD schools. Robbins Air Force Base, in the surrounding area, no DOD schools, over a dozen failing schools. And Fort Stewart and Augusta, no DOD, and 42 failing schools. So a lot of these kids were already falling into that bottom 25%, but this is just ensuring that for those 33,000 kids that qualify, that they will be on the list of eligible students to have that option for the Georgia Promises Scholarship. On your desks are 2 amendments, both presented by the Senator from the 19th. These are great amendments. I support them fully. I'll let the Senator from the 19th speak to it. But until then, I'm happy to address any questions regarding SB 124.
You do have one question. Senator from the 29th. Senator from the 29th.
Thank you, Mr. President. Senator Yield,
For my good friend from the 29th, absolutely.
Senator, would you reiterate the numbers that you initially gave of the Fort Moore numbers initially where you were talking about the failing?
25 failing schools in the surrounding area.
Senator Steele,
I do.
is it not true that the 25 failing schools in the surrounding area would be outside of Fort Moore in the Muskogee County School District?
They are, sir.
Thank you.
Recognize Senator from the 44th.
Thank you, Mr. President. Will this gentleman yield?
I do.
Thank you, Senator. You mentioned this a little bit, but since I'm on the committee, I would be, and was, reading the original bill in committee, can you please explain to me the difference between the language in the as filed that we heard in committee regarding the federal, the U.S. Department of Education and the state Department of Education versus these amendments that we now have?
So I'm going to let the Senator for the 19th speak to the amendments, which are separate from what you're seeing. So if you're looking at 1A, that's speaking to the amendment on 1, and then what's going to be following from the Senator for the 19th, this is just regarding calendar days and documentation on that. What we discussed in committee was the term of federal agency, and as was explained by President Lynn Riley, is where we fall into that. So in terms of line, so if you have a specific line number in the bill, I'm happy to get into that.
Sure, thank you. And I was just looking myself. So our conversation in committee, you answered my question regarding the necessity of the state school superintendent and Georgia DOE following guidance from the U.S. Department of Education, including but not limited to directives expanding educational freedom. Regarding that, you had indicated in committee in response to my question that directives from the U.S. Department of Education on educational freedom needed to be followed, but not other directives from the U.S. Department of Education. And I'm wondering if that's still your interpretation after the amendments.
It is.
So we still would selectively, we want our state Department of Education to selectively enforce what federal DOE is sending down?
Well, are you speaking to the amendment now, or are you speaking to the bill?
Well, I'm asking you to clarify for me, Senator. As
I'm going to allow
author.
the Senator from the 19th to speak to the clarification on his amendment and how it relates to that. I'll speak to the bill.
So, but it is still your interpretation that our DOE would only need to follow the
Yes.
ones about educational freedom and not their other work done by the U.S. DOE.
Yes.
All right, thank you, Senator.
Recognize Senator from 31st.
Thank you, Mr. Will the Senator yield?
I do.
Just a point of clarification, are you familiar with the directive from Secretary of Defense Pete Hegseth as of yesterday, March 3rd, sending Fort Moore's name back to Fort Benning as of yesterday?
I was unaware of the directive, but I'm glad to see it revert back. I don't think anybody was getting used to the name change.
Thank you, Senator. Great bill, and let's vote green.
Thank you, Senator.
You have no more questions.
Thank you, Mr. President. I ask you to please vote favorably on SB 124 and the two accompanying amendments.
I'm sorry. Senator, did you have a question, or you had a question? He had a question.
Yes,
I'm sorry.
thank you, Mr. President. You mentioned earlier, and I was trying to find it in the document about that there would be more students but no additional funding. How are they to be funded then? Is that local or federal dollars coming down to match the load or dictated by the federal government?
No, Dean, it's simply saying that children of active duty military only are now eligible for the Promises Scholarship. So they just go in line below those. They would be in line behind children below the poverty level.
But they will be, how will that fund, if, Senator Yield, I'm sorry.
Of course.
Is that federal dollars to pay for that additional load of students? Or?
It's not increasing the load. Once that cap is met, then it's met. It's not
I
gonna
understand it's met. Thank you, sir.
Yes,
I
sir.
yield.
Thank you, Mr. President. I yield the will.
Recognize the Senator from the 19th speak to the amendments.
Thank you, Mr. President. Amendment 1 and 1A just help move Senate Bill 22 that's just currently sitting in rules, hasn't gotten out yet, to the floor and get it on across to the House before crossover day. Senate Bill 22 is non-controversial, but it doesn't really have anybody screaming for it, so it's had a harder time getting out of rules. All it says is that all Senate Bill 22, which is now incorporated in this amendment, say is that when the state school board, state school superintendent, gets guidance from the feds that they have to follow, that the guidance must first be posted within 15 days of receipt, and then within 45 days of receipt, the state school board or the state school superintendent has to tell us how they intend to implement that guidance. And it gives a period of time for the legislature to respond and say, hey, we think that's appropriate or we think it's not. Amendment 1A is just procedural. You see, when I drafted Amendment 1, it's a little bit too long, and it would cause the senator from the 48th bill to lay over for one additional day. So we had to strike a few lines. Striking those lines, 31 through 35, that spend 5 lines saying that the school superintendent's going to give us a report. We were able to write that back on 1 line, so now it completes the Senate rule to not cause the bill to lie back and go to rules. That's all it does. Take any questions or wait? Or
You have no questions, Senator.
thank you.
Any other senators that wish to speak for or against the measure? Question is on the adoption of Amendment 1A, authored by the senator from the 19th. Is there objection? Without objection, Senator 1A is accepted. Second amendment is Amendment number 1, authored by the senator from the 19th. Is there objection? Without objection, Amendment 1 is adopted. Questions on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none, the report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none, the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. All those opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 37, the nays are 16. This bill having received the requisite constitutional majority is therefore passed by substitute. Senator from the 26th, to what do I owe this honor today for?
I don't know if you call it an honor or not. Parliamentary inquiry.
State your inquiry.
When can a bill be reconsidered?
You can serve notice for you can serve notice for reconsideration,
Right.
and then Thursday morning.
Thursday morning?
Mm-hmm.
You
Because we're
can't
not
do-
in tomorrow.
Can I do it now?
According to the rules, a motion for immediate reconsideration is not in order right now.
Parliamentary inquiry.
I tell you what, why don't you come up here and we can talk through it real quick. Secretary, read Senate Bill 124.
Senate Bill 9 by Senator Albers of the 56th and others, bills being titled an act to amend Part 1 of Article 3 of Chapter 12, Title 16 of the Official Code of Georgia annotated, relating to general provisions relative to obscenity and related offenses, so as to repeal and replace Code Section 16-12-80 relating to obscene material, distribution, and penalty, to amend Article 1 of Chapter 10 of Title 17 of the Official Code of Georgia annotated, relating to procedure for sentencing and imposition of punishment, so as to provide for sentencing of defendants who utilize artificial intelligence in the commission of certain crimes derived for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland, Chairman. Mr. President, Senate Committee on Judiciary offers the following substitutes to Senate Bill 9, a bill to be entitled an act to amend Part 1 of Article 3 of Chapter 12, Title 16 of the Official Code of Georgia annotated, related to general provisions relative to obscenity and related offenses, so as to repeal and replace Code Section 16-12-80 relating to obscene material, distribution, and penalty, and for other purposes. Mr. President, that completes the order.
Recognize Senator from 56.
Thank you, Mr. President. Senators, today I bring to you Senate Bill 9, the Ensuring Accountability for Illegal AI Activities Act. This crucial piece of legislation demonstrates our state's commitment to not only adapting to the rapid technological advancements of our age, but also ensuring the safety, security, and well-being of all Georgia citizens. As I mentioned to you yesterday when we passed the Georgia Data Consumer Privacy Protection Act, this was yet another recommendation from the Senate Study Committee on Artificial Intelligence, which met in 2024. In our digital age, we're witnessing a proliferation of artificial intelligence, or as we call it, AI. While these technologies can revolutionize many aspects of our lives, they also pose significant risks of misuse. The Ensuring Accountability for Illegal AI Activities Act is a timely response to this emerging reality. This bill specifically addresses the issue of obscenity, fraud, and related events. As you can imagine, the tools of today are so much more powerful than the tools of yesterday. With that, unfortunately, it has been used for harm, specifically against young girls, and fraud against everyday citizens and senior citizens. In fact, just over a month ago, right up in Gilmer County, someone who was working in the school used it to create illicit images of schoolgirls. Thankfully, that person is being held behind bars now while he awaits trial. This is critical to make sure we have properly added the right language into the legal code and sentenced accordingly people are using these powerful tools to commit these already illegal acts. But what does this mean for our average Georgians? And why should you, as their senators, care about this bill? Well, firstly, it ensures that our laws are up to date with current technologies and landscape so they can continue to protect us and protect us from potential harm. And this adds an additional layer of protection for Georgians against this misuse. Secondary, it maintains integrity of our judicial system by ensuring that anyone who uses AI to commit a crime is held accountable. It's not just about punishment, it's about deterrence. It's by establishing clear consequences and letting people know what the law is to discourage potential offenders, hopefully reducing the likelihood that such crimes ever exist in the first place. And finally, this bill sends a powerful message to our state's commitment with upholding the rule of law while embracing rapid technological change. In conclusion, the Ensuring Accountability for Illegal AI Activities Act is a forward-thinking piece of legislation that balances the need for technological advancement with our fundamental commitment to the rule of law. It's not just a response to the challenges we face today, but these are proactive measures to ensure safety and security for all Georgia's citizens in the future. I'd ask your favorable consideration. Mr. President, if there are no questions, I would yield the will.
You do have questions, Senator.
Yes.
Recognize Senator from the 27th.
Thank you, Mr. President. Chairman, do you yield?
Of course I yield.
Thank you for this bill. I understand what you're trying to do here. I do want to ask you, though, about Section 3, which is essentially a sentence-enhancing element of the bill, whereby the government can choose to ask for additional sentencing if AI was used in the commission of the crime. Is that accurate?
That is correct, because it is so much more of a powerful tool that in the past it has been used to perpetuate further and more despicable crimes.
Thank you. Do you further yield?
I yield.
I think I understand your intent. I'm wondering, and correct if I'm wrong here, because I very well could be. Let's take the offense of enticing a child for indecent purposes on line 71. Is there a scenario where a person could be given an enhanced sentence for using AI to simulate one of these acts versus the actual commission of the act? That would be my concern. And I'm wondering if I'm either misunderstanding it or if that's where we would just rely on the deference of the Attorney General, of the District Attorney at that point.
It would be that certainly the district attorney's prerogative in that case, but this would be using those tools in order to entice the physical child to do that. But I see where I believe you're going is, if something is done to an individual, that in itself is a crime. But what if it's done just to simulate something to somebody who does not exist, which is a legitimate question to ask? Who is the party that would be impacted by that? As an example, if someone were to create horrible and lewd images of a child in a way that would be wholly inappropriate and considered to be child pornography and other things, but it's not a real child, as an example, well, it's society as a whole that is the detriment to that versus it being a single person itself. And that's why the bill is constructed in this way, also to be consistent with what other states are doing.
Thank you, Chairman.
Thank you.
You have no further questions, Senator.
Thank you, Senators. I'd ask you please support this very important piece of legislation to keep our citizens safe and secure.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? The chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The questions on the passage of the bill by substitute. All those in favor of the bill will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 46, the nays are 9. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary reads Senate Bill 112.
Senate Bill 112 by Senator Dixon of the 45th and others. The bill to be entitled an act to amend Chapter 1 of Title 10 of the official code of Georgia annotated related to selling and other trade practices so as to extend certain protections for consumers relative to warranties of HVAC systems and components of such systems, to provide required information for warranty and product registration cards and forms, to provide an effective date for certain warranties of HVAC systems and components of such systems, to provide a definition, to provide for an effective date and applicability, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, Senate Committee on Regulated Industries and Utilities recommends that this bill do pass. Respectfully submitted, Senator Cowser of the 46th District, Chairman. That completes the order, Mr. President.
Recognize the senator from the 45th. Everybody woke up in here all of a sudden. Got loud all of a sudden in here.
Thank you, Mr. President. Colleagues, I bring Senate Bill 112 before you today. It's a good consumer protection bill. It has to do with HVAC warranties that are purchased by the manufacturer. Currently, if you buy an HVAC system and then you purchase an extended warranty, and in many cases you have to register that warranty or that item with the manufacturer, which is a needless step because they already have your information from purchasing the HVAC system and the warranty from you or from them. This bill simply takes that step out. The registration part would not be necessary. The warranty would commence once the item is installed by a licensed contractor, and it would also make the warranty transferable. Doesn't matter how many times the house is sold, as long as it's still under warranty, that would transfer with the new property owner. With that, Mr. President, be happy to answer any questions, or I'll yield the well.
Do you have one question, Senator? Recognize Senator from 26.
Gentleman yield.
I do.
Let me ask you questions. Since you're doing the warranties for HVAC, would you be willing to do warranties for folks who sell people a motor, say powertrain products, sells you a motor with a 5-year unlimited mile warranty, and the motor goes out at 89,000 miles, and then they tell you, well, the only way you can bring an action is in the court of New Jersey. Would you be willing to sign on to a bill like that to keep Georgia consumers from buying products which says there's a warrant, and then you get the writing, and the only way you can get an action is to go to the courts in New Jersey?
I'd be happy to support a bill like that, Senator, if you brought it forward.
Well, I'm getting ready to introduce one. I'm counting on you.
Thank you, Mr. President. I yield the well.
Any other senator wish to speak for or against the bill? Y'all in trouble now. The senator from 26 is wide awake right now. Y'all in trouble now. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to the agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 26th, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Mr. Governor, I'd like to serve notice that I would ask the Senate to reconsider House Bill 4 and giving it a constitutional majority.
Senate Bill 4? Senate Bill 4?
That, right.
Okay. On the passage of the bill, the yeas are 55, the nays are 0. This bill having received the requisite constitutional majority is therefore passed. Secretary reads Senate Bill 144.
Senate Bill 144 by Senator Watson, the 11th, and others. Bills being entitled an act to amend Article 6 of Chapter 7 of Title 2 of the Official Code of Georgia Annotated related to liability for use of fertilizers, plant growth regulators, or pesticides, so as to clarify that a manufacturer cannot be held liable for failing to warn consumers of health risks beyond those required by the United States Environmental Protection Agency with respect to pesticides, to provide for legislative findings, to provide for related matters, to provide for applicability, to repeal conflicting laws, and for other purposes. Mr. President, Senate Committee on Agriculture and Consumer Affairs recommends that this bill do pass by substitute. Respectfully submitted, Senator Goodman, Chairman. Mr. President, Senate Committee on Agriculture and Consumer Affairs offers the following substitutes to Senate Bill 144, bill to be entitled an act to amend Article 6 of Chapter 7, Title 2 of the Official Code of Georgia Annotated related to liability for use of fertilizers, plant growth regulators, or pesticides, so as to clarify that a manufacturer cannot be held liable for failing to warn consumers of health risks above those required by the United States Environmental Protection Agency with respect to pesticides, to provide for legislative findings, to provide for related matters, to provide for applicability, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
Recognize the senator from 11th. Class of 97.
Thank you, Mr. President. Members, I bring before you Senate Bill 144. This is a labeling bill. When you talk about crop protection tools and plant protection products, the label is the law. The United States Environmental Protection Agency approves the label. They will not allow anyone to put anything on that label that they have not done all of their research and fact-based, science-based research on, to allow anyone or any manufacturer to put anything on the label that they do not feel is true. So if it's not true or they can't verify it, they're not going to allow a manufacturer to do that. It does not lessen any restrictions. It does not provide any immunity. It just clarifies that a manufacturer cannot be held liable for failing to warn consumers of health risk above those required by the United States Environmental Protection Agency. That's what the bill does. We have on your desk several letters that I think you'll see. Just to mention some of those, our former governor and U.S. Secretary of Agriculture, Sonny Perdue, has a letter that speaks to the EPA and how they manage these labels in the process. You'll also see a letter from about 10 of our ag commodity groups. You'll also see a letter from the Urban Ag Council, the Georgia Chamber, and the U.S. Chamber. But again, this is just a label bill clarifying that. We also have a friendly amendment that will be offered by the senator from the 50th that we think strengthens the bills to protect the farmers, to make sure that those bad actors are dealt with. And so that's what the bill does, Mr. President, and I'll be glad to take any questions if there are any.
You do have a couple questions. Recognize Senator from 26.
Senator Yale.
Yes, sir.
Senator, with this labeling bill, will Roundup be able to sell their product because they've been sued about labeling? And just a little research on it, I found out that there has been no scientific evidence that Roundup causes cancer. And Roundup, you can do it at the house. You can get you a gallon bucket, take some Morton salt, and cut up some soap and mix it with it, and you got Roundup. Am I correct?
You are correct. Yes, sir.
And so what we are talking about, isn't it true? We are talking about not having to buy the product from China if we don't change it, because Roundup would no longer exist because you won't be able to buy it in the United States.
That's correct. There's been one study that a lot of the opponents reference, and in their statements they say that numerous studies suggest that glyphosate has issues. They also say probably carcinogenic. It doesn't say that it does, or that that it does cause this cancer or any other issues. That same study also references red meat, so maybe we should stop eating red meat. But you are correct, Senator. It is a we call it a trait technology in the farming world, and we use these products to make sure that we have a safe food supply, that our farmers' livelihoods are protected, and that food prices remain low. Mr. President, if there are no other questions, I'll yield the will.
There are no other questions, Senator.
Thank you. I greatly appreciate your vote.
Secretary, read the amendment.
Mr. President, Senator Hatcher, the 50th and others offer the following amendment. Number 1, to amend the Senate Committee on Agriculture and Consumer Affairs substitute to Senate Bill 144 by inserting after pesticides on line 5 the following, subject to an exception, by replacing line 40 with the following. To warn, provided, however, that the provisions of the subsection shall not apply when a determination has been made by the Environmental Protection Agency that a manufacturer knowingly withheld, concealed, misrepresented, or destroyed material information regarding the human health risks of such pesticide in order to obtain or maintain approval of its label by the Environmental Protection Agency. Mr. President, that completes the order.
Recognize the senator from the 50th. Nothing like a lawyer coming to rescue an ag bill. I'll tell you what. Gonna make it better.
Thank you, Mr. President, and I do appreciate that comment. This was worked on with the ag community and with the farmer in mind. One of the issues that we've seen across the country in the past is people push products without being fully transparent about the risk associated with those products. And the reason why a failure to warn claim is available to its citizens is because we think citizens should have autonomy in making a decision whether or not to expose themselves to something. So the Environmental Protection Agency has, apparently, according to the senator from the 8th, who has helped me with this, over 500 scientists that vet all these products, and they have to work with pesticide manufacturers, and pesticide manufacturers have to tell the EPA what they've learned about the product, what the risks are, and there are a lot of really good companies out there, and this will protect those good companies. But what we're trying to do here is make sure the bad companies are still held responsible. And so what this amendment does says that if it's found, if the EPA determines or discovers that you withheld information, that you concealed information, that you misrepresented or destroyed material information regarding the human health risk of such pesticide in order to obtain or maintain approval of your label, then that failure to warn immunity that's in here, failure to warn immunity, doesn't apply to you. So this is going to hold all the bad actors that lie to the EPA responsible, which is good for the farmers, it's good for the people of Georgia, and will hopefully continue to help agriculture be the #1 industry in the state of Georgia, and I'm happy to answer any questions about this.
No questions, Senator. Recognize the senator from the 19th.
Thank you, Mr. President. Senator, you yield?
I do.
Senator, this is a legit question. We didn't get to talk about it before. I apologize. Does the Environmental Protection Agency make determinations about information that's been knowingly withheld?
So Yes, they do. And when they find out that you have withheld information or they find out there's something wrong with their product, they can actually pull that label from you.
Recognize Senator from the 55th.
Will the distinguished gentleman yield?
Help me out here. There we go.
I
will.
In line with the distinguished gentleman, Chairman of Appropriations, is it not true that the distinguished persons who are called trial lawyers are the only ones who hunt and find out these situations where there is knowingly withheld? With the gentleman, is it not true that the Environmental Protection Agency, that's not their primary job to knowingly find out whether or not a manufacturer knowingly withheld, concealed, or misrepresented or destroyed material information?
Is that their job?
Is it not true that that's not their primary job?
Now, I know the EPA does a lot, and in Northeast Georgia, my constituents don't really trust the EPA, but we're going to make sure that at least manufacturers of these pesticide companies know that if they lie, they don't get the protections that we're affording the good companies.
And I applaud that effort to the gentleman in the well. However, you have on the piece of paper that was just provided to me, and I'm not on the committee that did this rule, and I am in agreement with the spirit of this legislation. However, on your line 5, if it says, and I will state this subsection shall not apply when a determination has been made that a manufacturer knowingly withheld, concealed, or misrepresented or destroyed material information. I simply ask with this, and I know this may throw a pebble into the pond, but if there is a determination by anyone, not just the Environmental Protection Agency, if there is a determination by anyone that a manufacturer knowingly withheld, concealed, misrepresented, or destroyed material information regarding the human health risks of such pesticide in order to obtain or maintain approval of its label by the Environmental Protection Agency. In other words, would it not be fair that the judicial system currently in place, through discovery or otherwise, determines that this material has been withheld, that liability should not be afforded to a manufacturer who does in fact withholds this information, whether it is determined by the EPA or not?
So I understand the Senator's concern. I thank you for that question. The issue here is that the EPA is the one that determines who gets a label and who doesn't, whose product is approved and who's not, and there's a rigorous process to go through. So if you do misrepresent something to the EPA and they give you the license or they let you continue to have, they give you the label or let you to continue to use it, then it is them ultimately that you've defrauded. And so that's why we decided to leave it with the EPA.
Will the gentleman further yield?
I will for one more.
Is it not true, for example, in the area of a famous case by Johnson baby powder, that was only discovered that they knew and withheld information that if that talcum powder was in the womb of a woman, that it remained there and caused cancer, and that was without the discovery and the adversarial judicial system, that we would never have found that out, let alone the Environmental Protection Agency?
Yeah, and if that information were to be found out moving forward after this passage, that information would be able to be presented to the EPA, and if they did find that they lied in order to get the label, then they wouldn't have the protection that we're affording them.
And I get the gentleman, but is the sentiment of the gentleman to only give immunity if the Environmental Protection Agency, which is a federal agency which has less staff now, in fact, 4 of the 5 people that are now currently employed at the EPA it is my understanding that only one of those people out of 4 will be remaining at the EPA. Is that not true?
That's information that I'm sure the senator knows of what he speaks, but I don't have that information.
Well, and I will relent, gentlemen. If the gentleman further yield just another time here, is it not true that if there is any determination by a manufacturer knowingly withholding, concealing, misrepresenting, or destroying material, that they should not enjoy immunity?
That is, if you withheld information from the EPA and the EPA finds out about it, you shouldn't have immunity. That's correct.
Well, the sentiment of this language is only if the EPA makes that determination. What if a court of competent jurisdiction makes that determination that a manufacturer knowingly withheld, concealed, misrepresented, or destroyed material information? Would you agree that they should then not enjoy immunity?
Based on that, based on your line of questioning, I understand where you're going with this, but the EPA, if that were the facts, the EPA would determine that they withheld information. There's very specific things that you have to show the EPA in order to get approval. And so if you don't show that to the EPA, they will determine that you withheld, misrepresented, or destroyed material information.
So basically, if there was a legislation proposed that would clear this up to say that if there is a court of competent jurisdiction that did so find that this manufacturer knowingly withheld, concealed, misrepresented, or destroyed material information, that they should not, in fact, enjoy immunity?
I think I've answered the question a couple times here, but essentially, if it is determined by the EPA that you withheld information in order to obtain or maintain a label, you will not get the protections that this bill seeks to afford.
Thank you. I would ask that you support legislation that not only affords the EPA that determination, but any court of competent jurisdiction. Thank you.
Thank you. Mr. President?
Yes, sir. You do have a couple more questions.
I'll go one more.
Well, I got to go with who was there first. The senator from the 41st.
Thank you, Mr. President. Senator, do you yield?
I do.
Thank you for bringing this friendly amendment. I just want to make sure that I'm understanding what's happening here. So are you saying that if a company X, is found to at some point have withheld information that knowingly hurt the public, then they would no longer be able to say that they were covered by the immunity of failure to warn? Is that what you're saying here?
If it's determined by the EPA that they did, yes.
And is it not true that your bill also allows that the EPA could determine that based on evidence from a court of law, like that court of law, some lawsuit could be brought to the EPA for them to make that determination? Is that correct?
I believe that's correct, yes.
Yeah. And then finally, just for my own clarity, this is asking as a non-lawyer to a lawyer, if someone were to be harmed by one of these pesticides, is there another way for someone to sue that does not fall under the failure to warn posture? Like, is there another way to get damages?
There are several ways, yes.
Do you further yield?
For one more, yep.
Could you expound on some of the ways that people might be able to be made whole even if they can't sue under failure to warn?
Negligence, federal tort claims, there are other avenues.
Thank you.
Thank you. Mr. President, with that, I'll yield the well.
Recognize the senator from the 44th.
Thank you, Mr. President. I know that the authors of this legislation are very well-meaning, and I want to say very clearly at the outset that I support farmers and I support agriculture, Georgia's top industry. But It's my view that the bill is a misguided attempt to help farmers that actually, unfortunately, just provides immunity for a multinational manufacturing conglomerate when there are thousands and perhaps millions of people out there that may have gotten cancer from one of its products, Roundup. So first about Bayer. Bayer bought Monsanto. Monsanto was the manufacturer of Roundup, so now Bayer owns Roundup. Bayer is comprised of 340 consolidated companies spanning 80 countries. It's headquartered in Germany. It is the definition of a huge international conglomerate. This is not some American mom and pop company. Now, about Roundup. Bayer has been losing in court on lawsuits alleging that Roundup causes cancer, and most recently lost in the 11th Circuit, our own appeals court, which is probably the direct impetus for the legislation we see today. Scientific studies are mixed on Roundup. Many global health organizations state that glyphosate, the key chemical ingredient in Roundup, is likely carcinogenic to humans. In fact, the EPA decreed this, that glyphosate was a likely carcinogen, all the way back in 1985. But after a pressure campaign by Monsanto, where Monsanto championed falsified data and attacked legitimate studies that revealed Roundup's danger and led a prolonged campaign of misinformation to convince government agencies, farmers, and the general population that Roundup was safe, the EPA reversed course. So here's an example of a study. The initial test that EPA approved Roundup under was run on rats for 2 months and showed no correlation with cancer. But later studies run for 2 years, which is much more in line with the lifespan of a rat. 80% of the rats got cancer versus 30% of the rats in the control group. And moreover, the tumors in the glyphosate rats were up to 130% larger than the tumors in the control group. Monsanto then manipulated peer reviews about this study, that particular study, and actually hired the editor of the journal, had the editor of the journal where it was published on their payroll to grease the wheels to make sure that it would get retracted and that the EPA would then, and we're talking 40 years ago, go ahead and approve glyphosate and say there was no correlation with cancer. So now 40 years later, due to its repeated losses and mounting liability, Bayer is searching for a way to limit its exposure at the expense of regular folks. And believe me, a lot of those regular folks are farmers. A lot of those regular folks are farmers. Last year, Bayer pushed for legislation in Missouri, Iowa, and Idaho. It lost in all 3 states. Probably partially because Iowa has the second highest cancer incidence of any state in the United States of America. And there were plenty of farmers showing up at the Iowa Capitol asking them to not pass a liability immunity bill for a company that was lying about its product for 40 years. So because it lost in all the states it brought the bill last year, it shifted its messaging. I gotta give it credit, it's very clever. Now it's all about protecting American businesses from China, since it didn't work last year to just say, please protect us, an international conglomerate headquartered in Germany, from lawsuits from American farmers. Meanwhile, as an indirect but important aside, there are weird health things going on with folks that none of us can yet ascertain the cause of or put our fingers on. They can't be directly isolated by scientific studies, at least not yet, but we should be aware of them. Are y'all aware that the global sperm count has been declining precipitously in the last few decades? Precipitously. In one French infertility clinic, more than 55% of sperm samples contained high levels of glyphosate. We also have a significant rise in autism over the past 20 or 30 years, and it's likely that environmental causes are behind it. Now, that is not my opinion. I've talked to noted Georgia health experts about it. What exactly it is, I couldn't tell you, and I wouldn't pretend to say I can isolate one chemical or endocrine disruptor versus another. It's probably various chemicals, pollution, and increasing overall saturation in the soil, the air, the ocean, etc. We don't know, but we can't just ignore the brightly flashing warning signs. Okay, now to the actual heart of the problem with this bill. It pretends that the EPA is an appropriate regulator that always will act decisively in the best interest of the public. That is not the case. In fact, one of the top folks at the EPA right now just showed up there from running the American Chemistry Council, the exact industry agency, industry lobbying group that is lobbying for all these chemicals, including bills like this, to make sure that chemical companies can't be held accountable if their products cause harm. Just a few years ago, this particular woman, who's now running the EPA, was busy lobbying in DC and telling legislators that formaldehyde does not cause cancer, and probably succeeding with it. I've got a personal story that shows how weak these regulators are, and the American public should be able to rely on them, but we can't. So when I was first sworn into the House in 2011, I had a 10-month-old baby. So, like anyone with a 10-month-old baby, I was a recent consumer of purchasing baby bottles. And when I'm out making my baby registry for friends and family, I couldn't help but notice that all the displays in all the stores on all the baby bottles and baby products said BPA free. So I get down here, and my friend Scott Holcomb, who's still in the House, who also had young children, we talked about it. And we were like, you know what? Let's file a bill to ban BPA in baby bottles here in Georgia. So we did. You can look it up. Representative Holcomb was the primary author, and it was bipartisan. We had Republican co-signers. Well, the next thing that happened is that the Georgia Chemistry Council showed up to kill the bill and talk about how there's no evidence that BPA causes anything, and certainly the Georgia House should not entertain that bill, which never got a hearing. Meanwhile, studies for a while had shown that BPA had an ability to mimic estrogen, potentially impacting developments in infants, including brain function and reproductive health. 5 months after the Georgia Chemistry Council managed to make sure that our bipartisan bill did not even get a hearing on BPA, the EPA banned BPA in baby bottles. But why? Because the American Chemistry Council asked them to. That's right. 5 months after they were busy killing our bill, they asked the FDA to ban BPA in baby bottles. Why? 2 reasons. Number one, no manufacturers were making bottles with BPA in them anymore because no one would buy them. The market for it had already completely disappeared, and yet they were still down here fighting against the bill. After they submitted their petition, because the market had completely deserted baby bottles with BPA, the FDA, then went ahead and banned it after the Chemistry Council asked them to. So the reason they did that, number one, no one was making them anymore. And number two, there was legislation pending in Congress that would have banned BPA in a larger group of customer plastics, right? And they wanted to ward that off. So this is the regulator we're now saying we want to put our faith in. Someone that did not ban BPA until the industry lobbying group asked them to, when literally no one was even making it anymore, because through lawsuits and through studies, the public had already wised up that they should not buy these things because they could be harmful to health. So to the senator from the 50th point, it is important that these lawsuits get brought. And I'm certainly not putting my faith in a regulator that did not ban BPA until the whole world already had decided it was dangerous and they weren't going to buy it for their family. The reality is that the FDA, just like the EPA, is an imperfect and weak regulator that is neutered all the time by the lobbying and interference of companies like Bayer and like whoever was making the BPA plastics. Federal legislators respond to those interests and money. It's easy to confuse the public. Remember all the times we said that smoking didn't cause cancer? It went on for many decades, right? Many decades. I think it was some lawsuits that finally forced that to end, those lies to end. The companies have money, they want to be able to sell their product, and they can and do lie and twist the regulatory process to their advantage. The public should be able to be informed on these things. If a product is causing harm, we should not give it legal immunity at the outset and decide that debate. Because at the end of the day, multinational chemical companies like Bayer should be held accountable. I'm not necessarily telling you that Roundup or glyphosate should be banned, but we need to get real. If these companies are not willing to have a strong and effective regulator in the EPA or the FDA, and they most certainly are not willing to have a strong and effective regulator, then we have to have lawsuits on the back end so that the public finds out what's being hidden. I don't believe we would need so many lawsuits if we had a more effective regulator. But because the companies interfere with the regulators, with lawsuits, and right here in this Capitol and in the Capitol in DC, they want to own every step of the process and have no liability or regulation anywhere in the process that interferes with their ability to sell their product and make money. And they don't really care that much how many people have cancer. It is not the government's job to clean up Bayer's mess by siding with it over citizens and giving it a pass. So therefore, I will be voting no on this legislation. I understand it's well-intentioned, but when you really know what's going on here, I would say, please beware, because you're fed a lot of lies all the time that things are safe by our castrated regulators in Washington, D.C. And I am happy to answer any questions, or I will yield the well.
Senator from 36.
Thank you, Mr. President. Says Senator Yield.
Yes, ma'am.
Isn't it true that you have painted a compelling picture of the poisoning of the public by corporate misbehavior that's fueled by huge money influencing those who are supposed to be regulating and protecting the health of our people here in this country?
Well, I hope it's compelling, and I think that there are many examples of it happening. You know, the senator from the 50th a few weeks ago referenced Aaron Brockovich, referenced the scandal with Teflon and DuPont behind the Dark Waters documentary, and there are many other examples. So yes, I think all of us remember the punitive damages associated with the Ford Pinto case all those years ago. They're
That's
there
right.
for a reason.
And isn't it true, we've had, for example, people coming up here from Juliet, Georgia about what's in their water.
Yes, ma'am.
These are not fairy tales, isn't that true? These are not things that people have dreamed up. These are examples of people seeing cancer all around them for their own loved ones and the people that live on their street or in their subdivision or in their town. And repeatedly, there are really, I would almost say, countless examples of how people wake up and find out that they've been damaged. Isn't that true?
That is true.
By a product of a powerful, well-funded corporation that is able to skew the regulatory process with their influence and their money. Isn't that true?
That is true, and it's not just skewing the regulatory process. Understand, of course, that any scientific study to isolate any one chemical is incredibly difficult, right? So they can use that to their advantage. I would be fine with Bayer, Monsanto, whoever, if they said, look, there are mixed studies on this. Some say that that it's not cancer causing, but some do. So in the interest of, letting the public know, they can then weigh the risks and decide to buy it if they want. But that is not what they do. They deny, and interfere all along the way with anyone's attempt to warn the public.
Further inquiry, if you'll yield.
Yes, ma'am.
PFAS.
Mm-hmm.
PFAS. I first learned about the dreadful outcomes from exposure to PFAS. The forever chemicals, I think people have heard about it now here in Georgia. Their water systems and their manufacturers, people have been exposed to PFAS, which are forever chemicals. And it's happening right here in our state, and it is yet another example when there is a belief that you can trust the manufacturer to fully disclose what's known about a product.
Mm-hmm.
Isn't that
Yes.
true?
Yes, ma'am.
And we've had, I can call the names of the industries up there in North Georgia that have been dumping in the water, and their water systems that are compromised with PFAS. Isn't that true?
That is true, and I believe we have some municipalities suing right now.
That's exactly
and
right.
And some other immunity bills that the industry is trying to ram through here.
That's right. And I raise that, isn't it true, because it's buyer beware.
It is.
Don't assume that because something is out there and available means that it's safe. Quite the contrary, isn't that the case? And we could learn right here in Georgia, isn't it true, from the example of PFAS in the water, forever chemicals in our water, from industries dumping, and people severely compromised or losing their lives as a result. Is that not a compelling warning it's a way to look at this and understand, is it not true, that this is a giant multinational corporation that is skewing the process, and people's lives and health are at stake. And that, I would contend, is the thrust, is it not true, of the remarks that you've brought with us today.
That's right. And I think that PFAS is another one of those that's been linked to the conspicuously large decline in sperm counts nationwide. I'm sorry, internationally. And the real fallacy in this legislation is saying that the EPA and the FDA really will not let anything out there that isn't safe. Y'all, that's just a load of cow manure, I gotta tell you.
Thank you for
Thank you.
Providing a high warning here that I would hope that our colleagues would heed. Thank you.
Thank you, ma'am. I yield the well.
Senator's yielded. Recognize Senator from the 14th.
Thank you, Mr. President. So as to stave off any suspense, I rise today in support of this legislation. And I want to talk about the echoes in my mind that I hear in a quiet space when I'm thinking about food security and the environment. And that echo in my mind is the voice of the senator from the 8th asking, do you like to eat? Eat, eat, eat. Because the answer is I do like to eat. And in my district, from exits 2 to exits 10 on Georgia 400, there are not a lot of farms. I'm not sure if there's a single one. And if you grow up in a district like that, you might think Waffle House falls from the sky, like rain. It does not. It comes from farmers. People in other parts of the state that I don't spend as much time in, whose day in, day out job is to feed not 10 people some decades ago on average, but over 150 or more people. So a tenfold increase in the amount of mouths that farmers must produce yield in order to feed. And if I drive my Hyundai Sonata far enough outside of my district, down I-16 or to other parts of the state, down I-75, what I find is a larger state that exists in a community with the metro Atlanta area in ways that must be recognized for us to legislate effectively at the Capitol. I was opposed to this legislation for a lot of the reasons that the senator from the 44th mentioned. I'm generally skeptical of a large corporation going around to state houses and trying to broker an immunity deal. I opposed the governor's tort reform package, at least half of it. The other half I voted for. And so it's not an easy vote for me to step outside of my district, step outside the box of the way we traditionally do things, and to listen to Georgia's farmers. But Senator from the 8th, other voices in the building, the letters on our desk have made it clear. We have a real food security issue. And if I can steal the Senator from the 8th's thunder, what is it we always hear? You know, the right is okay with corporate consolidation, and the left maybe likes regulation a little bit too much. In the middle is the farmer. Farmer gets squeezed. And if there is a real risk, which I buy that there is, that this chemical, which has been used for decades, might be pulled from the market if there is an increasing liability issue on this one specific cause of action, to be clear, failure to warn. There are other lawsuits that might still be available. But I buy the argument that if the chemical is pulled off the market, we could have a real issue with yield and also with national security. It matters where our inputs for ag are coming from. If they are sourced from other countries, then we have less security as a country than if our inputs are sourced domestically. So here I am, an attorney from the Roswell Road area, Georgia 400, who hasn't spent much time with dirt on my hands, who is standing up here saying that for the good of the statewide community, for the good of our food security both in the state and nationally, I'm going to support this legislation today. And I hope that we can do this type of legislating when it comes to lawsuit reform or whatever in the future, which is targeted, which is justified by need, and is not the sort of blanket sweeping types of legislation that we have been doing. I'll yield for any questions, or I'll yield the well.
You do have one question, Senator. Recognize the Senator from the 47th.
Thank you, Mr. President. Would the Senator yield?
I will, Senator.
What did you do with the Senator from the 14th?
So we recently had him on as a guest for an episode of Trump Morning News, and he had a terrible fall. And so I'm here in his place, but I appreciate you asking. Hopefully he'll do better soon. With no other questions, Mr. President, I will yield the well. Thank you.
The Senator has yielded. Recognize the Senator from the 41st.
Thank you, Mr. President. I rise today as someone who grows food for my community in Stone Mountain, Georgia, a small little farm that feeds half dozen, maybe a dozen families during the summer and provides eggs all year long. And I don't use these products. I have 90 blueberry bushes, and we don't spray them with anything. But in a few minutes, I believe that the senator from the 8th is going to show you a chart. And he will show you what happens to blueberries when they're not sprayed. And I can tell you from firsthand that we lose at least probably a quarter to half of our crop to blueberries that have those diseases because we don't spray. Now, because I'm not trying to make a living with those blueberries, because I am clear about kind of the community that I'm serving, it's okay for me to lose a portion of my crop in order to not have to spray them with pesticides. But I am clear based on the number of blueberries that grow fungus on my own property, based on the pounds and pounds of tomatoes that go to my goats because they have been infested. I'm clear that we cannot feed our country and our world without having help from pesticides, fungicides, and other agents. I know that organic farming matters. I do it myself. And I do it so that I can feed my family, but we cannot feed the world in the ways that we need to without having some type of pest management. And so I say that as a person who's doing this. I hope the senator from the 8th, he'll speak here, but he's sending a video around where he's showing blackberries that have these little worms that come out of them. I've got those blackberries that have the little worms that come out of them because I don't spray them. We've chosen not to use pesticides. Again, that's a decision that we've made for ourselves, for our family, because we know that we can grow enough to meet the needs of the people that we're trying to meet. But if you want to do this on a large scale, like the senator from the 8th does, you just need to have some additional help. And so I stand here today in support of this bill. I stand here today in support of farmers who are trying to feed our nation and indeed feed the world. With that, I yield the will.
Thank you, Senator. Recognize the senator from the 8th.
Where is my, there it is. You know, colleagues, I have spent most of my adult life since I graduated from the University of Georgia Ag School fighting for farmers. And I have said this everywhere that I go. I say the three biggest threats to the family farm in this country are corporate consolidation, overregulation, and unfair trade. I say that to everyone that I talk to. I no longer believe that. After serving in this building, after the trips that I've taken to Washington, those aren't the greatest threats to the family farm. The greatest threats to the family farm are that the 2% of us that are feeding and clothing the country, the other 98% doesn't have a damn clue what it takes. That is the biggest threat. My grandmother was born in 1923. When she was a little girl, you know what they said? They farmed her. What she said? Well, when you lost your crop, she said they got the blight. That's all they could say, it got the blight. In 1923, the American farmer feed about 12 people a year. The average life expectancy was 53 years old. Today, the American farmer feeds 169 people, and the average life expectancy is 77 years old. Do we want to get rid of modern medicine and modern agriculture? When we talk about plant protection products, we would lose over 70% of our yields across the country if it were not for plant protection products. I brought that from my packing shed. That shows you what, without plant protection products, fungicides, herbicides, insecticides, we're talking about famine is what we would have. We have got to increase our food production by 70% by 2050 to be able to feed the world. The only way we go back to a world without plant protection products is let's go back to 1880 when 80% of the people lived on farms. That's the only way you're going to do it. Now, I brought up somebody to meet with both caucuses. His name is Dr. Stanley Culpepper. Now, don't let his unassuming ways and the way he talks country like I do. The man is world renowned. He is the only person in extension across the country to ever serve 3 consecutive terms on the EPA Advisory Council under both Republican and Democratic administrations, because he's respected on both sides of the aisle. He's written over 137 peer-reviewed publications, and he was awarded an award in the White House, where he was given the award in the Oval Office. In rural Georgia, just because we talk slow doesn't mean we think slow. And so when we have a letter on your desk from Sonny Perdue, who is a former Secretary of Agriculture, we bring these experts up. There are over 500 scientists that work at EPA. And you look at the list, this study that this stuff come from, I want y'all to understand where I'm coming from. This is some of the things that they said could be possibly carcinogenic. Acrylamide, you know what that is? That's a cooking emission that is formed naturally during high-temp cooking processes, frying, baking, and roasting. Hydrochloride, that's in your medications, your antibiotics, your antihistamines, your pain relievers, Advil. Ethyl carbamate, that's in bread, soy sauce, beer, wine, distilled spirits. Red meat. Hot coffee. Non-arsenical insecticides. You know what that is? That is bifenthrin. That's pyrethroids. That is the things, when we talk about public health, think about the diseases that mosquitoes and ticks, for everybody living in these urban areas. Think about that. That's on the list. But by the way, guess what else is on the list? Night shift work is a possible carcinogen. And this is the last one. Emissions from burning wood in a fireplace. That's on the list. So you have to ask yourself this. This is not about one company, and it's not about one chemical, because we all know that the things on this list, when one gets dried up, you're going to move on to the other. And when you think about plant protection products, and you think about what we have to feed the American people, you can listen to a few people that are out there that don't know what the heck they're talking about, or you can follow the science. We feed our children the stuff that we grow. Think about that. We talk about following the science. Follow the science. But I can say this. I sent that video out to everybody. A video of blackberries. We have a little fly that we have to do preventative sprays for. And the same thing that we use, some of those compounds that we have to use to treat for that little fly, it's called a spotted winged Drosophila. You can Google it. Little bitty old miniature fly. And it lays a little bitty hole you can't hardly even see in a blueberry or a blackberry or a strawberry. And it takes 7 days, it lays larvae. And it takes 7 days for that larva to turn into a worm. So when mom or dad, they go to the Publix or the Kroger or whatever else, and they buy that pretty clamshell of Georgia-grown blueberries. They beautiful. They got that bloom. They carry it home, and they put it in the refrigerator. 2 days later, mom opens up the refrigerator door, and guess what you got? You got white worms crawling all over those blueberries. That's what you're going to have. So I'm just going to say this. Besides food security, if that's the world you want to live in, a world without plant protection products, then vote against this bill. Mr. President, I yield the will.
Amen. Somebody really want to follow that? You really want to follow that, Senator? Huh? Senator from 7th.
Thank you, Mr. President. I rise in opposition to Senate Bill 144. Today, we are considering a bill that puts corporate profits ahead of public health. Senate Bill 144 is not about protecting farmers. It's not about strengthening agriculture. It's about giving chemical companies a free pass while stripping Georgians of their right to hold them accountable when their products cause harm. This bill would block lawsuits against pesticide manufacturers as long as their labels have been approved by the EPA. But let's be honest, EPA approval is not a gold standard. The agency doesn't even conduct its own independent safety testing. Instead, it relies on studies provided by the very companies selling these products. And history has shown us that some of these companies knew their chemicals were dangerous and worked to hide the risks. We've seen this before. Monsanto, now owned by Bayer, has already paid out billions in lawsuits because their Roundup herbicide has been linked to cancer. And now they want to change the law so they never have to pay again. They want to make it impossible for farmers, landscapers, and everyday Georgians to seek justice when they suffer from pesticide exposure. That's what this bill is really about. Let's talk about who this bill hurts. Farmers who trust these products and then get sick. Families living near agriculture areas who are exposed to toxic chemicals. Workers handling these pesticides every day without knowing the full risks. If they develop cancer or other illnesses, Senate Bill 144 would slam the courthouse doors shut in their faces. And I keep hearing that the purpose of this bill is to continue to allow farmers to use these pesticides. Like, these pesticides are not going anywhere. This bill is not about helping farmers. It's about silencing lawsuits. Because if companies were confident their products were safe, they wouldn't need legal immunity. I'm going to repeat that one more time. If companies were confident their products were safe, they wouldn't need legal immunity. If this bill passes, Georgia would be shielding pesticide manufacturers from accountability and all the expense of public health. Colleagues, we're not elected to protect corporate polluters. We're elected to protect the people of Georgia. And Senate Bill 144 takes away their right to seek justice. It prioritizes profits over people, and it sends a clear message that if a product makes a company money, it doesn't matter if it makes people sick. I refuse to accept that, and I refuse to let Georgia be another testing ground for corporate immunity, and I urge every one of you to vote no on Senate Bill 144. I yield the bell.
Secretary, read 1A, Amendment 1A.
Mr. President, Senator Tillery, the 19th, offers the following Amendment 1A to amend Amendment 1 to the Senate Committee substitute of Senate Bill 144 by adding after agency on line 8, as long as the pesticide is available for retail or wholesale sale to Georgia farmers. Mr. President, that completes the order.
Senator, would you like to speak to 1A?
Hey, thank you. I'm okay with the bill as it is. I'm okay with no amendment passing. But the comments that we've heard here is, hey, there's 49 states that this is probably going to get banned in, and we're the only one that's going to waive a failure to warn. What I do hear that. And what makes me afraid there is that a large company, a large corporation, would then make the decision of, heck, one state's not a big enough market for me, so I'm pulling it off the shelves anyway. What this amendment does is says, hey, Georgia farmers, we're going to give you an additional protection. If they pull that product off the shelf in Georgia, well, the failure to warn that we likely are about to waive goes away. It makes them want to stay in Georgia if they're going to offer it at all. It doesn't put us in a position where we're the only state to waive the waiver, and they still yank it off the shelves, and 49 other states are suing them for it. That's all it does. Take any questions, or I'll yield the well. Actually, I'll just yield.
You didn't have any questions. Senators yielded. Senator from the 11th, would you like to close debate?
Thank you, Mr. President. I think I mentioned when I started my comments that this bill was about the label, strictly about the label. And Bayer has been mentioned, who's they have 50% or better of the market on glyphosate. This all started because of one study that the senator from the 8th has already mentioned, but the company was not allowed to put the warning on the label because of the EPA. They were not allowed to put it on the label. Therefore, it led to 170,000 lawsuits at a cost of $17 billion. And now my future and my family's future and many other farmers across this nation's future are in jeopardy. I know what it feels like to lose crop protection tools, Before I started growing vegetables, we lost methyl bromide. It was the best product we had for weed control, for insect control, for nematodes. The product was gone because the EPA said that it destroys the ozone. Well, guess who's using it? Mexico, Argentina, all the countries around the world are using it. Well, guess who we're buying vegetables from today? Those same countries. The same goes for labor. The same goes for regulations. We're at an extreme disadvantage. This just piles it on to all of those disadvantages that the American farmer has. So we can not have this, not pass this, whatever, and we can depend on foreign countries who are going to use these products. China's using the products. We're going to buy it from China because that's going to be the only way that we can feed Georgians is to buy it from China, and that's what we're going to do because that's what we have to do to stay competitive and feed people. So it's about the label. If they want to do this, if they want to put something on the label, they can't unless the EPA says it's okay. So we're just saying that they control that, they oversee that, and we're clarifying that so that we don't have these problems and that the threat of losing this crop protection tool doesn't leave our state and the United States. As far as these amendments go, I really don't know. I got a lot of these last minute, and obviously just hard to process what some of the consequences of some of this will be. So I don't really want to speak to that. I'll just tell everybody to do what you want to on those amendments. But this is an important bill. If we want food security, if we want to protect our farmers, the livelihood of our farmers, and keep food prices low, and know where your food comes from, that's another thing. We're able to go after people here in the United States. We're able to go after Bayer when there's a problem. Let's go after the Chinese when they put this product on the market or whatever else they're doing. Who are we going to go after? How do you go after the foreign countries and the foreign manufacturers? So let's just get rid of all the domestic production of all these crop protection tools, and let's let China continue to put it on the marketplace, and we can buy it from them because then we don't have to worry about it. It gets really complicated, and I appreciate the comments from the 8th, but just great to appreciate your support for this, and I yield to Will.
Thank you, Senator. Recognize Senator from the 19th.
Thank you, Mr. President. I need to withdraw 1A. I put it in the wrong spot while drafting.
Is there objection to that? Without objection, 1A is removed. All right, we're going to take up, Senator from the 11th has closed the debate now. We're going to take up Amendment 1, authored by the Senator from the 50th. Is there objection to Amendment 1? Without objection, Amendment 1 is added. Question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 42 and the nays are 12. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Good job, Senator from the 11th. Secretary reads Senate Bill 160.
Senate Bill 160 by Senator Kirkpatrick, the 32nd, and others. Bills being titled an act to amend Code Section 40-6-390.1 of the official code of Georgia annotated related to reckless stunt driving, so as to replace the forfeiture penalty of a motor vehicle involved in a second offense of reckless stunt driving with authority to order the installation of a device which limits the speed of such vehicle, to provide for a definition, to provide for procedures and conditions upon issuance of such orders, to provide for notification to the Department of Revenue, to provide for a penalty, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers, Chairman. That completes the order, Mr. President.
Recognize the senator from the 32nd.
Thank you, Mr. President. Reckless stunt driving, including laying drags, is something that the General Assembly has been addressing for several years. That's because the behavior is dangerous and ends up causing fatalities, about 150 per year across the country. The senator from the 10th led on legislation on this previously, and yet the behavior has continued in many parts of the state, especially the urban areas. This bill simply provides that if a person is convicted a second or subsequent time of reckless stunt driving, a court is authorized, not mandated, but authorized to order installation of an intelligent speed assistance device on the vehicle operated by the offender, which limits the speed to no more than 70 miles an hour. ISAs is the acronym. They've been used in Europe for many years, and states are beginning to use this technology to control excessive speeding, including street racing and reckless stunt driving. There are multiple manufacturers of the equipment, and the cost ranges from $200 to $1,600 to be paid by the offender. The technology is similar to an ignition interlock device. The bill does not impound the vehicle, so the person is still able to go to work and drive wherever they need to go. This bill provides a way to control dangerous speeding activities as a matter of public safety using proven technology. And with that, I'd be happy to answer any questions.
Senator from the 10th, or you want to ask a question or you want to come speak to it for the measure? Okay. All right. You have no questions, Senator.
Thank you.
Recognize the senator from the 10th.
Thank you, Mr. President. I rise in support of Senate Bill 160, and I just want to thank the senator from the 32nd for the work that she's doing. When I looked at this bill and she asked me to sign it, I knew instantly that it would be a great way to add on to the work that this body has passed in this chamber for the last 4 years. It gives those offenders an opportunity to keep control of their car, but yet have these limiting devices. So again, I just want to thank the senator from the 32nd and encourage all of my members to join us in supporting this bill. 56-0 would be nice on the board. Thank you, and I yield well.
Thank you, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Secretary reads Senate Bill 177.
Senate Bill 177 by Senator Anna Vitarte, the 31st and others, a bill to maintain an act to amend Chapter 5 of Title 21 of the Official Code of Georgia Annotated related to government transparency and campaign finance, so as to provide for transparency in foreign-funded political activities within the state, to require agents of hostile foreign principles and foreign-supported political organizations to register with the State Ethics Commission, to provide for registration requirements, to provide for definitions, to provide for legislative findings, to provide for civil penalties, to authorize the Attorney General to bring civil actions or criminal investigations for violations, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Ethics recommends that this bill do pass. Respectfully submitted, Senator Watson, Chairman. That completes the order, Mr. President.
Recognize Senator from the 31st.
Thank you, Mr. President. I'm going to be very brief. Senate Bill 177, this bill addresses two issues. This is a bill we passed out of this chamber last year that was sent to the governor, vetoed, and we fixed the correction as it relates to the foreign countries of concern and how they were documented in the bill. This bill addresses two significant issues. One, transparency and representation by lobbyists representing hostile foreign nations and individuals and entities. And second, the funding of protests and political activities by hostile foreign governments and their agents. Mr. President, I'll yield unless there's questions.
You do have one question. Senator from the 14th.
Thank you, Mr. President. Does the senator yield?
Yes, to my friend from Georgia 400.
Senator, I noticed that on line 43 of this bill, the bill defines hostile foreign country to include the Russian Federation. Was that the intent of the author?
So, Senator, under this language, yes.
Do you think the majority might want a friendly amendment to leave that determination to the discretion of the sitting president, Senator?
You know, Senator, we heard they canceled your morning news, so I think that was the time to raise it. But I think basically this is basically referring back to what's in federal code, so we're just going to leave it alone.
Senator, I want to say I agree with the determination. I'm glad that the good majority party in the state of Georgia knows who our friends and our enemies are. Thank you very much, Senator.
Thank you, McLaurin.
You have no
Mr. President, I yield.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Senator from the 22nd. I'm sorry, what'd you say? Oh, Senator from the 7th, would you like to speak? Floor is yours.
Thank you, Mr. President. Let's be honest about what Senate Bill 177 is. It's a weapon, a tool designed to silence dissent, intimidate advocacy groups, and make political participation in Georgia a risk rather than a right. This bill claims to protect us from hostile foreign influence, but in reality, it grants the state unchecked power to investigate, penalize, and even criminally charge organizations that challenge those in power. We already have federal laws like the Foreign Agents Registration Act that addresses foreign influence. So why are we duplicating efforts at the state level, creating a bureaucracy with no real oversight, no clear limits, and massive penalties that could crush grassroots organizations? Because this bill isn't about national security, it's about selective enforcement. This bill is so broadly defined, we don't know who's going to be next. Civil rights groups, labor unions, student organizations? Senate Bill 177 gives the Attorney General sweeping discretion to decide who gets investigated, who gets fined, and who gets prosecuted. And all it takes is an accusation. No due process, no clear safeguards, just a government crackdown on political opposition. And let's talk about these so-called disclosures. Under this bill, any organization that received any funding whether it's $1 or $1 million, from a vaguely defined foreign source, in the past 5 years must register and open their books to the state. That includes groups working on humanitarian causes, immigrant services, or international aid. The message is clear. If you're advocating for change, you are a target. And the penalties? Fines up to $200,000, with the Attorney General empowered to initiate criminal investigations. That's not regulation, y'all. That's intimidation. We cannot allow this government overreach to stand. This bill is a direct attack on free speech, free association, and the right of the people to organize without fear of retaliation. Colleagues, we have a choice. We can either uphold the fundamental freedoms that make democracy work, or we can open the door to a system where political participation is met with fear and punishment. And I refuse to let our state go down that path, and I urge you to please vote no on Senate Bill 177. I yield the well.
Senator's yielded. Senator from 22nd. He waved. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 36 and the nays are 18. This bill, having received requisite constitutional majority, is therefore passed. Moving on to Senate Bill 241. Secretary.
Senate Bill 241 by Senator Williams of the 25th and others, bill to be entitled an act to amend Chapter 18 and Title 43 of the official code of Georgia annotated related to funeral directors and establishments, embalmers, and crematories, so as to provide that the organic human reduction as a means of disposing of deceased human bodies, to amend Titles 10, 31, and 36 of the OCGA related to commerce and trade, health, and local government, respectively, so as to acquire a disposition permit for the organic human reduction of a dead human body or fetus, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Regulated Industries and Utilities recommends that this bill do pass. Respectfully submitted, Senator Cowser, Chairman. That completes the order, Mr. President.
I recognize the senator from the 25th. The last man to ever let you down.
Thank you, Mr. President. Ladies and gentlemen, I come before you today with Senate Bill 241. This is something serious. This is dealing with our loved ones. This is, I know there's a time for jokes and there's a time for laughing, but this is something that a lot of people take very serious, and I do too. It's just taking care of our loved ones. You know, I've been in the funeral business all my life. My father was, my sons are. And this is something that we take very serious. But there's been some incidences that have happened. Noble, Georgia, Tri-State Crematory. This was because there were no laws regulating crematories in Georgia. And people could just do anything they wanted to do, and that's what happened. There was people in Colorado just a few months ago had started a composting business of composting human remains. That state had no license requirements, no guardrails regulating that method of disposition. No one was inspecting them. No one was looking over their shoulder. No one was taking notice of what they were doing. They were just assuming they were doing the right thing. Turns out they absconded and left town with all the money and left the building vacant. The power was shut off, and they had over 118 decomposing human remains, other people's loved ones that were being disregarded and neglected. This is the purpose of this bill, is to make sure that Georgia has guardrails to prevent Colorado from happening, Noble, Georgia Tri-State Crematory from happening. This is to make sure that our loved ones, should we choose this method of disposition, that it would be guardrails placed in place to prevent this neglect from happening. Right now, the methods of disposition in Georgia are burial. We even have green burials. We have a monastery in Conyers that offers green burials. You have cremation, alkaline hydrolysis, donation to medical schools and other research facilities. So even because of religious practices and even other customs of other people or countries or religions, that embalming and different types of burial are taking place. And Mr. President, with that, I'll be glad to take any questions if there are any.
You do have one question, Senator. Senator from the 29th.
Senator, does Senator yield?
I do.
Senator, could you tell me the difference between this type of burial and a green burial?
A green burial would be burial in a cemetery that the body is placed in a grave, and there are no mechanical devices used. It would be lowered with ropes and even wrapped in a shroud or placed in a natural casket that could decompose. This type of disposition would be in a sterile facility that's designed exactly for this, and it's much like a medical facility that the body is placed in an individual capsule, and it is allowed to decompose and to go into this natural composting state, and then the compost can be returned to the family if they wish it, and that compost can be placed on their farm, on their property, or donated to a land bank.
Thank you.
Thank you for the question.
You have no questions, Senator.
Thank you, and I yield the well, and I ask for your favorable consideration. Thank you.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee, which is favorable to the passes of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 52 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Senator from the 41st, what purpose do you rise?
Thank you, Mr. President. I ask for unanimous consent to excuse the senator from the 22nd.
From the 22nd? Without objection, the senator from the 22nd is excused. Secretary Reed, Senate Bill 180.
Senate Bill 180 by Senator Dixon of the 45th and others. Bills to be intended to enact to amend Article 7, Chapter 4 of Title 20 of the Official Code of Georgia annotated related to high demand apprenticeship program so as to provide opportunities for apprenticeship sponsors to enter into a apprenticeship program, contracts with State Board of the Technical College System of Georgia to provide for completion awards to apprenticeship sponsors for the successful completion of such contracts, to provide for later matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Higher Education recommends that this bill do pass. Respectfully submitted, Senator Burns, Chairman. That completes the order, Mr. President.
Recognize the senator from the 45th.
Thank you, Mr. President. Colleagues, I bring Senate Bill 180 before you today. It has to do with high demand apprenticeship programs, which was initially created in Senate Bill 379 in 2022. The purpose of this program was to incentivize apprenticeship sponsors to establish and grow existing registered apprenticeship programs in the state of Georgia. Last year, under the senator from the 4th leadership, the program was amended to make improvements to it. The 88 AP program has been successful and has been successfully supported by industries around the state, encouraged new apprenticeship programs, and for those programs to grow. Given the demand in many industries, such as construction, electrician, and others, we need to support additional apprenticeship programs and providers throughout our state. We've come back to today to make one change to the bill from last year, and all it has to do with is providing more access under TSG. The apprenticeship sponsor is the one difference in the bill. Currently, you would have to apply with basically a company. The company would be your sponsor, and then they would take those funds. They would receive those funds, and then it would go to the high demand apprenticeship program. The way the bill changes is that the student could go directly to the apprenticeship program instead of to just the company that would sponsor them. The reason for this is just for access. Some students may not know many electrician contractors, and the schools have a list of them, so it just kind of helps open that up. With that, Mr. President, be happy to answer any questions.
You have no questions, Senator.
Thank you, Mr. President. I yield the well.
Does any other senator wish to speak for or against the measure? Chair, is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the reported committee which is favorable to the passage of the bill? Chair hears none. The reported committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passes of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed.
Senate Bill 63 by Senator Dixon of the 45th and others, bill to be entitled an act to amend Part 15 of Article 6 of Chapter 2 of Title 20, the official code of Georgia annotated related to miscellaneous provisions under the Equality Basic Education Act so as to require that local school systems offer certain exams to home study students, to provide for notice requirements, to prohibit additional qualifications, to provide a definition, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Hickman, Chairman. Mr. President, Senator Dixon of the 45th offers the following amendment number 1 to amend Senate Bill 63 by replacing lines 23 to 26 with the following. C. No school system that offers the PSAT, NMSQT, SAT, pre-ACT, or ACT, or an advanced placement exam to students enrolled in such a local school system shall require home study students to pay a fee not required of students enrolled in such a local school system, or impose any requirement that conflicts with or is in addition to the requirements of subsection C of Code Section 20-2-690. That completes the order, Mr. President.
Recognize the Senator from the 45th.
Thank you, Mr. President. Colleagues, I bring Senate Bill 63 before you today. It has to do with homeschool students with their advanced placement testing for college. Currently, certain school systems, I've had about a dozen parents in my home county of Gwinnett. Also heard from parents across the state where homeschool students, it's been made very difficult for them to take those advanced placement tests. Sometimes they're given a location on the other side of the county from where they live. They also have to pay for the test. I heard from a mother today that lives in Albany, and she had to travel to Columbus for the ACT test for her daughter. Had to incur a hotel expense and had to pay for the test. Simply what this bill does is it would allow homeschool students to take those tests at their residency school. If there's no charge for those tests for those students, the homeschool students would not be charged. If there is a charge, they would pay that same charge as well. And it's simply access to these tests. Those students, those parents are paying their taxes just like the rest of the students' parents are, and just give them access to these tests. The amendment, it just brings in the code section where homeschool, where that law was created. I'm just kind of clearing that up. But with that, Mr. President, be happy to answer any questions.
You have no questions, Senator.
Thank you, Mr. President. I yield well.
Is it all right, Senator? He secured your vote. We know this thing's all right then. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the amendment authored by the senator from the 45th. Is there objection to the amendment? Without objection, Amendment 1 is added. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question on the passage of the bill. All those in favor of the bill vote yea. All those opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. This bill having received requisite constitutional majorities, therefore pass as amended. Senate Bill 110, Secretary.
Senate Bill 110 by Senator Enna Vitarte, the 31st, and others, bill to be entitled an act to amend Code Section 15-11-2 of the official code of Georgia Annotated related to definitions relative to the juvenile code, so as to revise the definition of neglect and to provide for new definitions, to amend Code Section 16-5-60 of the official code of Georgia Annotated related to reckless conduct causing harm or endangering the bodily safety of another, and conduct by HIV-infected persons, so as to provide for an exception to certain offenses of reckless conduct for legal custodians permitted to children to participate in independent activities under certain conditions, to provide for later matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Children and Families recommends that this bill do pass by substitute. Respectfully submitted, Senator Kirkpatrick, Chairman. Mr. President, the Senate Committee on Children and Families offers the following substitute to Senate Bill 110, a bill to be entitled an act to amend Code Section 15-11-2 of the official code of Georgia Annotated related to definitions relative to the juvenile code, so as to revise the definition of neglect and to provide for new definitions and for other purposes. That completes the order, Mr. President.
Break it down, Senator from the 31st.
Thank you, Mr. President. Senate Bill 110 makes Georgia's open-ended definition of neglect much more specific and fair, giving families across the state notice that it is their right to let their children do a few things. Travel to and from school, simple things we would think. Travel to and from school, including walking, running, bicycling, engaging in outdoor play, being home for a reasonable amount of time, engage in similar independent activity. Senate Bill 110 allows parents to make these family decisions and determine when their child is of sufficient maturity, physical condition, and mental abilities to avoid substantial risk or physical harm. The bill clarifies that neglect is the denial of quote-unquote necessary care to a child, creating an environment that is obviously injurious to his or her welfare. This tightening of the definition of neglect comports with the public's understanding that the state should not intervene in family life unless the parent's actions or omissions cause a serious risk of harm to the child that is obvious to a reasonable parent. Current law allows authorities to label a parent a child neglector based on their own moral judgments without evidence of a parent endangering a child or health safety. This bill is necessary so good, caring families are not getting swept up in the criminal justice system or child welfare systems intervening with their kids, either by choice or necessity. This bill is about families having more freedom, independence, us not relying on the government to solve all our problems, whether that's DFACs, in many cases in some of our neighborhoods, law enforcement, pretty much common sense. So, Mr. President, I'll yield if there's a question or two. Thank you, Mr. President.
Does any other senator wish to speak before or against the bill? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Question on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the Board of Committee which is favorable to the passage of the bill? Chair hears none. Board of Committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Senate Bill, Secretary Reed, Senate Bill 126.
Senate Bill 126 by Senator Dixon of the 45th and others, a bill to maintain an act to amend Code Section 20-2-2096.1 of the Official Code of Georgia annotated related to definitions relative to the Completion Special Schools Act so as to lower the age of eligibility from 18 to 16 for certain students to be enrolled in a completion special school, to revise definitions, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Hickman, Chairman. That completes the order, Mr. President.
Recognize Senator from the 45th.
Thank you, Mr. President. Colleagues, I bring Senate Bill 126 before you today. It has to do with our completion schools here in the state, which would be referred to as Mountain Ed, Foothills, and Coastal Plain. Essentially, 2 years ago, there was a House Bill 87. It changed a few different components to the completion schools. They were referred to as state charter schools before that, but it raised the dropout age from 16 to 18. And what that's done in the past 2 years is it's dropped the enrollment rate by about 50% in these schools. And unfortunately, these kids that attend these schools, this school gives a very flexible option to the time of day that these kids can attend school. They can go during the day, they can go at night, they can take classes online, and they can do a combination of all those as well. A lot of these kids that go to these schools, I've been to several graduations. Foothills is in my district. A lot of these kids are at risk of not graduating at all, maybe getting a GED, whether they've started a family early, whether there's sickness within the family, or they've just got to simply go to work to help support the family. This gives them that option. They also don't have to fit in that cohort of 4 years and a semester. It gives a lot of flexibility to these children. And if we lose these kids, in which, like I said, the enrollment rate has dropped by 50%, I would say a majority of these children have actually just entered the workforce. More than likely, most of them won't get a high school diploma, at best maybe a GED, and we all know that's not equivalent to a diploma. By dropping this age, I think it would bring it back in line and help and get the enrollment rates back up, but more importantly, get those kids diplomas in their hands. With that, Mr. President, be happy to yield for any questions.
You have no questions, Senator.
Thank you, Mr. President. I yield the well.
Do you want to speak for the bill? Oh, I'm sorry, Senator. He wanted to ask you a question. It was the other button you need to mash, though, Senator. It's the other button, though, for a question, Senator.
You yield?
I do.
Tell me, what is the age to be required to be in school? Is the age 6 to 16 to be in school?
At the age of 16, in traditional schools, like your residency school, you could drop out at 16 or choose to go to homeschool or go to any other type of like dual enrollment, things of that nature.
Yeah. So if a child or student drops out at age 16, and then under the current bill, they cannot apply to come back to the completion school until age 18.
That's correct.
So they're theoretically out of school 2 years then before they come back, which probably means they won't ever come back. And I think that's why we've seen such a tremendous drop in enrollment. I mean, in Coastal Plains, I think we've actually saw a drop in enrollment about 1,000 down in that area. So those are 1,000 students that are not in school, 1,000 students that probably may not even get the GED, 1,000 students that may be roaming the streets. So to drop this age back to 16 really makes a lot more sense. Is that correct?
Yes, sir, it does, Mr. Chairman. It makes a lot of sense. And yes, you take any child out of the school setting at the age of 16 for 2 years, the likelihood for them coming back and getting a diploma would be very low. And a lot of these kids, like I said, I've been to several of these graduations. You got a lot of entrepreneur spirit children that are in these schools, but life has hit them, at a very fast rate for whatever reason that may be. Mm-hmm. And to take them out of school for 2 years, more than likely, most of them will just enter the workforce.
And the example I gave you about Coastal Plains is the same type of example for Foothills and Mountain Ed. I mean, we're losing thousands of kids dropping out because the age is 18 instead of 16.
That's correct.
Thank you. Thank you, sir.
Thank you.
Now you have no questions, Senator.
Thank you, Mr. President.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 50, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Secretary reads Senate Bill 154.
Senate Bill 154 by Senator Hatcher the 50th and others, bill to be entitled an act to amend titles 20, 35, and 43 of the official code of Georgia annotated related to education, law enforcement officers and agencies, and professions and businesses, respectively, so as to revise or remove references to the United States Department of Education from the official code of Georgia annotated to replace a reference to student aid reports with FAFSA. Submission summary to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Hickman, Chairman. Mr. President, a minority report to Senate Bill 154 has been attached. Mr. President, Senator McLaurin, the 14th, offers the following amendment number 1 to amend Senate Bill 154 by replacing inserting or its successor after on line 11 and inserting or its successor after on line 34, both with the word pile driving. Mr. President, that completes the order.
Senator from the 50th.
Thank you, Mr. President. Rise to bring you Senate Bill 154. It's a short bill, but it's an important bill moving forward in the state of Georgia. If and when the U.S. Department of Education is ever disbanded, I referenced our code section, and in 25 different places we actually refer to the U.S. Department of Education. Of most importance, it deals with licensing professionals. And so in order to become a licensed professional in the state of Georgia, you have to graduate or complete a certain school that is recognized by the U.S. Department of Education. If that goes away, technically, peace officers, social workers, dentists, dental hygienists, dental assistants, massage therapists, optometrists, psychologists, speech-language pathologists, and audiologists, the list goes on, they would not be able to be accredited or be licensed in the state of Georgia. So this bill, what it says is wherever it refers to the U.S. Department of Education, you put a comma after it and put or its successor. And I'm happy to answer any questions, but I ask for your favorable consideration.
You have no questions.
Thank you, Mr. President. I yield the way.
Senator from the 14th, would you like to speak to your amendment?
Thank you, Mr. President. Good afternoon, colleagues. I bring to you Amendment 1 to Senate Bill 154. The problem with this bill is if we're going to get rid of the Department of Education, we need to go all the way, brother. What needs to happen is you've got to eliminate it from the code entirely. Just putting or its successor implies the Department of Education is allowed to exist, brother. That's unacceptable. Okay? We've got pro wrestling experts who we have put in place to pile drive the Department of Education. So let's do the same thing in the code, brother. That's all this amendment does. I'm counting on you to vote yes on Amendment 1 so that we can bring the level of seriousness and expertise and skill to this discussion of the Department of Education that the moment in history requires. I'll yield for any questions, Mr. President.
Shockingly, you have none.
Thank you, Mr. President.
He's back. We were worried about you earlier. Recognize Senator from the 36.
Thank you, Mr. President. Colleagues, I'm sure that the author of the bill, the senator from the 50th, has the best of intentions, and I'm not attempting to sully those. He's probably trying to prepare for the coming storm, if you will. I would suggest a better option would be to all sign a resolution resolved that the Georgia Senate opposes the dissolution of the Federal Department of Education. I think that would really handle this situation. It's disturbing, and that's putting it very mildly, to see people that I know better. You served on school boards, you sent your children to public schools, you live in communities where public schools are celebrated. You know a lot of teachers. You know a lot of educators. You know countless people who have committed their lives. Their entire career has been in the service of educating our future generations. And this notion that has cropped up, and you hear it. You know, one of the classic ways to swing public opinion, you're supposed to repeat the message. What does it say? At 12 times, people start catching on, and they say, well, everybody's talking about it. Well, I hear people saying, yeah, we ought to close down that department. I'd love to hear any one of you make a convincing argument for how the Federal Department of Education should be closed down. And we've got the facts and the figures. And the reality is that having a Federal Department of Education plays a critical role in funding, in researching, and in leading the way for good practices in education. And I am just almost speechless at the thought that I'm looking into the faces of people who think we ought to shut down the Federal Department of Education because a certain person said that, again, not someone who is in any way experienced or even intelligent about the question of education, K through 12 or higher education. But it's become this clarion call, and it's disturbing to see members of the Republican Party who know better chasing like lemmings toward the cliff of, yeah, we got to all get on board and shut down the Federal Department of Education. We have former college presidents in this body. We have school board members, my gosh, probably 24 people here have served on school boards. How many of us have raised children and sent them to school? And what is the magic elixir here? What is this special potion of shutting down the Federal Department of Education? Any takers? Come to the well and explain to us why that's a good idea. Now, I understand that the senator from the 50th is attempting to prepare for the coming storm, and change our language now in the state code so that we can proceed with education at the magic moment that the king up in Washington rules that woman who runs the wrestling crowd, that he's appointed her to be the head of education, federal education. And he's appointed for one reason, to take it down. So I can understand the efforts of the good senator from the 50th, who I know is a supporter of good public health policy, good medicine, and good education. That's who he is, and he's a great dad as well, and a family man. And I know his intentions are honorable. But could we not race like lemmings to the edge of the cliff and push each other out of the way to be the first in line to say, I embraced the concept of shutting down the federal Department of Education? People, we're at a moment here. We're at a moment. I mean, if you really sat back and thought about it, it's a preposterous notion, and making trying to marginalize educators and attack the Department of Education that has done innumerable good and that plays a critical role in funding all sorts of educational initiatives for our state. It's just like we heard when USAID the other day was shut down, and children are now dying from that around the world. And we heard an explanation of how bad the USAID is. It's been around for 60 years, keeping malnourished children alive instead of burying them. Let's gather up our senses and act collectively on behalf of, for the good of our people. You're going to go home and tell your school teachers and your principals and your school superintendents, we went down there and got ready for the coming storm. We changed all the parts of our code around education so that we'll be ready for when the federal Department of Education is shut down by this woman from the wrestling world. Think about it, people. Hadn't got a good look. And in the real world, it's another attack on fundamental structures and infrastructure in our civil society that has been working for a long, long time. But watch out, will it be next weekend or the one after that when you get the turn in your resignation? We've got a lot of dangerousness and foolishness going on in Washington, and we'd be well served to bring some common sense to the table and not race like a lemon to the edge of the cliff and fall over. I will yield if there are any questions. I will yield for questions, and if not, I'll yield the well.
You do have
Seeing none.
You do have a couple questions, Senator. Senator from the 38th.
Thank you, Mr. President. Does the gentlelady yield?
Yes, to the senator from the 38th.
Is it not true that the U.S. Department of Education was started by Georgia's only United States President, President Jimmy Carter?
You are correct. President Carter, from the small town of Plains in the southwest portion of our state, who won a seat and served as our president honorably, launched the Federal Department of Education.
Thank you. Is it not further true that in order for the U.S. Department of Education to be gone away, it would require congressional approval? Is that not true?
Well, that is my understanding. I do also know that there are repetitive lawbreakers right now in Washington that are taking great pleasure in kicking over everything and knocking the props out from under our civil society and our governance. So I'm not surprised that they might attempt to do it without the congressional action, but they would be breaking the law. Yeah.
That's right. And is it not further true that on Friday, staffers were told by Elon Musk and his minions that they could get a $25,000 buyout if they quit by Monday?
That's exactly right. That's what that Musk guy did. Yeah.
Thank you. And is it not further true that should the United States Department of Education go away, those responsibilities would fall upon the states, and therefore we would actually be growing state government in order to implement the work that is done at the United States Department of Education?
You make a great point, and it really underscores the lunacy of this approach that we're seeing coming from the current administration.
Thank you.
Thank you for your question.
Recognize the senator from the 53rd. But you can yield at any time.
Thank
Senator.
you. You mean there's another question? From my friend from the mountains.
Yes, Senator. We both have our roots in Tennessee. Senator, do you consider yourself well educated?
Well, I could answer that quite seriously. I always thought I knew a little bit, but when I stepped into the streets in 1964, 63, in the March on Washington, I learned so much that day that taught me I had been miseducated as a white Southerner. There's a couple of ways to answer that. I try to stay informed and up to date, and anybody can be wrong sometimes. You hope to be right most of the time.
So, Senator, are you indicating that you're not happy with your education?
I'm sorry?
Are you not happy with your education or your educational background?
Well, the hour is late. I don't know how much rumination you want me to do about that, but I went to school in Virginia. They've got great schools there. But I was raised in the segregated South, where white people were given a certain narrative. We were raised in a certain way with a certain set of beliefs being promoted in the white Southern culture. So in that sense, I realized I had been seriously miseducated and undereducated about some very important things about this country's history and the dynamics and what people based on their race had been subjected to in this nation.
Do you think if there would have been a federal Department of Education when you graduated, you would have had a better education?
The Federal Department of Education, when I graduated, I was, let's see, that would have been prior to the formation of the Federal Department of Education. We had a good education system in many significant ways in Virginia. I compared it favorably with what I found in Georgia when I got here. If there are no further questions, I'll yield the well.
Oh, you got one last question, Senator from 28th.
Senator from the 28th is standing. That your district number was changed, Senator. I apologize for not recognizing it. I'm still relearning these new district numbers.
Not a problem. Will you yield?
I yield, certainly.
Isn't it true that the Federal Department of Education is in charge of disseminating different grants and monies to all the state Board of Educations?
And I know your family comes from a lifetime of professionals in the world of K through 12 education, and that is correct.
Also, isn't it true that if it goes away, if it's abolished, that it's going to trickle down different problems to all the state school boards?
I believe you're correct. I view it as a dangerous action that's being proposed in Washington.
Absolutely, and these are perilous times already in education. We have so many problems. Isn't it true that we definitely need to keep all? And it'll trickle down. So, of course, if we lose the national federal Board of Education, then it's going to come down to the states as well.
I would agree. And we're going to see in Georgia a heavy burden to continue the work of educating our next generation of leaders in the absence of the Federal Department of Education. And folks, just hold up the idea that President Carter launched this laudable effort with the best of intentions of expanding and improving our educational systems, not only in Georgia, but across the country.
Thank you very much.
Thank you, and I will yield the well. Thank you.
Thank you, Senator. All right. Does any other senator wish to speak for or against the measure? And the senator from 50, do you wish to close? All right, floor is yours.
Thank you, Mr. President. Where to begin with that? The purpose of this bill, which I clearly stated, was if and when the U.S. Department of Education is disbanded, Georgia needs to be able to move forward. We need to be able to graduate police officers. We need to be able to graduate nurses. We need to be able to graduate dentists. To the excellent point from the senator from the 28th, we have federal grants that we rely on, and we need to be prepared for that. I'm here to make sure that Georgia can move forward. But I understand this is a very political issue, and people have pointed some fingers. The minority report, I'm going to have to disagree with the wording of it. But I will say this. On October 17th, 1979, when Jimmy Carter established the U.S. Department of Education, the United States was ranked number 1 in the world in high school and college education. Now, I'm not up here advocating for Donald Trump to do away with the U.S. Department of Education. I'm advocating for him to do what's best for our country. And in this room, we were elected to do what's best for this state. And what they do at the federal level trickles down to us, and we need to be prepared. So if you want to do what's best for Georgia and prepare Georgia's citizens, our children, and our schools for what could potentially come, vote for this bill. If you don't, vote no. I'll yield the well. Thank you.
Senator has closed debate. Questions on the amendment number 1 authored by the senator from the 14th. Is there objection? There is objection. All those in favor of the amendment will vote yea. All opposed, nay. Secretary, unlock the machine. On the adoption of amendment number 1, the yeas are 21, the nays are 32, and this amendment has failed. Is there objection or agreed to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. Main question is ordered. Questions on the passage of the bill? All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 37, the nays are 17. This bill, having received requisite constitutional majority, is therefore passed. Secretary reads Senate Bill 201.
Senate Bill 201 by Senator Walker, the 20th, and others, bill to be entitled an act to amend Code Section 10-1-393 of the official code of Georgia annotated related to unfair or deceptive practices in consumer transactions, unlawful and example, so as to provide increased consumer protection for homeowners entering into contracts with contractors following natural disasters, provide for certain contractual requirements, provide for notice language to amend Code Section 33-6-5 of the official code of Georgia annotated relating to unfair methods of competition and unfair or deceptive acts or practices, so as to prohibit the assignment of benefits in certain circumstances, to provide for definitions, to provide for related matters, to provide for legislative findings, to repeal conflicting laws, and for other purposes. Mr. President, Senate Committee on Insurance and Labor recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Walker, Chairman. Mr. President, Senate Committee on Insurance and Labor are following substitute to Senate Bill 201, a bill to be entitled an act to amend Code Section 10-1-393 of the official code of Georgia annotated related to unfair or deceptive practices in consumer transactions, unlawful and example, so as to provide increased consumer protections for homeowners entering into contracts with contractors following natural disasters, and for other purposes. That completes the order, Mr. President.
Recognize the senator from the 20th.
Mr. President, I think this is the bill many of us have been looking for today. Not only is it a good bill, which is one reason to look forward to it, but it's the last bill on the rules calendar for the day, so I know there's some excitement around that. Senate decorum restrains me from explaining this bill in my best imitation of my favorite wrestler, the Nature Boy, Ric Flair. Woo! Or maybe Stone Cold Steve Austin, but seriously, colleagues, Senate, we've had some acrimony in the chamber today. We've had some strong disagreements, strong opinions, one way or the other. I think this is a bill we can all get behind. I hope we'll have a unanimous yay vote on this. It adds to Georgia's Fair Business Practice Act some protection for Georgia homeowners in their probably toughest time of need after they've suffered a natural disaster and had damage to their home. Sadly, what we have seen, we saw it after Hurricane Michael, we've seen it again after Hurricane Helene. Some unscrupulous contractors will come in and try to take advantage of people when they're sort of at their most vulnerable moment and under a lot of pressure to get their roof fixed or their home fixed, and they're nervous because they see all their neighbors' property damaged, and they think they better hurry up and sign a contract and get in line, or they won't get their work done in a timely manner. So what this does, it adds Section 36 to the Fair Business Practices Act to give protection in this event. So if a contract gives a homeowner the ability to get out of a contract that they may sign with a contractor if the contractor does not perform the services in a timely manner or in an appropriate manner, and it also allows them, if they file an insurance claim and let's say they have some roof damage and they believe that the insurance company is going to pay for the roof damage, and they find out from the insurance company that the claim is only going to be partially covered, or maybe the claim's not going to be covered at all, it gives them 5 days to get out of a contract for the roof repairs in that example. And then lastly, it prohibits insurance companies from assigning the insurance benefits to a contractor of a person that lives in a county that's been declared a national state of emergency and suffered damage to their property due to a natural disaster. So good consumer protection measure to try to eliminate some of the shady practices we see after a big time storm or natural disaster. Mr. President, I'm happy to answer any questions. If not, I will yield that well and ask for everyone's favorable consideration.
You do have one question. Senator from 19th.
Thank you, Mr. President. Senator, you yield?
Yes, sir.
Senator, thank you for this bill. Is it not true that by putting this code section under the Georgia Fair Business Practices Act, you actually create a cause of action with a penalty of $150,000 per violation?
That's not really my area of expertise, but I'm sure that you know of what you speak.
Senator, will you yield for one other question?
Yes, sir.
Is it not true that when you did your Ric Flair imitation earlier that your hair did not move at all?
Thank you, Senator. All right, I yield the well.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the board committee which is favorable to the passage of the bill? Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Congratulations, Nature Boy. You won another one. Recognize the senator from the 16th. For what purpose do you rise? Okay. Recognize the majority leader for a motion.
Mr. President, I move that the Senate stand adjourned according to Senate Resolution Number 6 until 10 a.m. on Thursday, March the 6th.
Secretary, read the announcements.
Mr. President, the Regulated Industries and Utilities Committee meeting has been canceled, and tomorrow at 12:45 p.m., the Rules Committee will meet in room 450 in the Capitol. That completes the order, Mr. President.
Senator, floor is yours.
For those that are on government oversight, we're going to meet tonight for the dinner at Fogo de Chao at 6 o'clock. And if you've not contacted the office, that's great. Come on and we'll look for you at 6 o'clock. Thank you.
Any other announcements? Any other announcements? All right. Majority Leader has moved that Senate stand adjourned until Thursday, March 6, 10 a.m. All those in favor signify by saying aye. All those opposed, no. Ayes clearly have it. Have a good evening.